Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Or getting commentary on the tape. Dati mihi Anglican praise service.
Is that correct?
I didn't ask you to interrupt me.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Let's see. I think I am. Here we go. There we go. It's here. Good morning. Hope you're having a fabulous Tuesday. I just want to double check. Yes, in fact, it was Greeners. Greeners won the internet today. Congratulations, Greeners. Again. It's weird. It's weird being in a new time zone. Okay? I know I've been here for a couple weeks, but I have not adjusted. You're standing for a second longer. Our butler is finishing the cleaning on the seats. We should be ready here in a moment. Hang on a second. I don't know why it didn't run that time. There we go. Give it a second. They'll start working here in just a minute. And I think, we need an update. That's why. Okay. It's working now. We're back up and running. All right. Let's see. It's how I know RA is about to start when the advert kicks in. Mike, this bugs me. Mike, this bugs me. Let me just tell you why. If I can go on a mini rant here. Since the day I started live streaming as a partner, YouTube partner, basically it's from the time that my channel got monetized, where YouTube splits ad revenue with me. YouTube has been encouraging me to show more advertisements on my live streams. And literally every single time, there's no way I can get around this. Every single time I start a live stream, it does a pop-up window suggesting that it just should put ads in just every time there's a pause, a break, a change of scene, things like that. And that it could just do it on its own. And it would take care of it. And they constantly tell me how much more ad revenue I could earn if I did that. And it's like 15 to 50% more ad revenue. And I have said no every single time. And now they just start doing it. And I say I want to control when the ads go in, which means I manually can go in and I can say insert ad. Like I could click a button right now and all of you would get an ad. That's how I set it up. And I set it up saying I'm going to do that, but then I never push the button. And YouTube is taking away the privilege of not having ads. So I'm frustrated. I don't like watching ads. First of all, I don't trust that that it's going to put it in at the right time, that it will be an appropriate ad for what I want to watch. And I don't like breaking up the drama of court just because there's a pause and like a mic drop moment in court. I don't want to see an ad for something I don't want in the middle and then possibly miss the response. I don't know how it works. And when the ad stops, are you behind? Like 30, 60 seconds, does it put you behind? Or do you come back and just miss that section of court? Either way, I don't think it's good. So sorry for the ads. I wish I could make them stop. I can't. All right. YouTube Premium is worth it for no ads. If the money is right for you, I know it's more expensive. It costs a few bucks for sure. But the ads go away completely. So it makes you behind. See, the problem with being behind, and that's cool. It's cool. I mean, I appreciate YouTube and the platform. I love it. But the problem with being behind is you don't know that you're behind sometimes. And then the conversation in chat gets really convoluted because we've got people watching 2 minutes before and 2 minutes after based on how many ads people have seen. So, all right. Also, YouTube has sort of inappropriate ads. Now drives me crazy. YouTube sent me an email saying, we'd like you to consider turning on sensitive categories on your channel, including advertisements for alcohol and gambling. And I'm like, have you seen my channel? Do you know what my channel's about? Have you read my channel name, Recovery Addict? Oh my goodness, it was funny. All right, good morning. Rant is over. It's time to start the day and get watching court. Here's what we have. We have let's see, bring that here. Where is we're 2 hours away from the Robert Tellis start, so we're gonna do a little court hopping there. Let's see. So we've got a few things to do. We can do birthdays. I see birthdays on the list. Hang on. I'm going to add one, Sharon, and that was my fault. But I'm going to add Connie to the list. That's somebody who's not watching, I don't think. Maybe I'll play the replay for her, but I don't think she's watching right now. We'll add her anyway. Sorry, I'm having microphone problems. There we go. That's better. I'm going to add Connie. So we're going to sing to Kieran Baines, Hannah Fullwood, and Connie. All celebrating their special day today. That means all of us get to sing together. We've had plenty of time to warm up, right? Well, if not, let's do it now. La 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 la. There we go. All right, stand up, shoulders back, deep breath, project to the back of the room. Blend your voice with those of your neighbors. We're going to sing to Kieran Baines, Hannah Fullwood, and Connie. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Kieran Baines, Hannah Fullwood, and Connie. Happy birthday to you. Kieran Baines, Hannah Fullwood, and Connie. Happy birthday. Realize there are a million places you could be, a million people you could be with. We've chosen to celebrate here with us. Hopefully we can make your day a little more specialer. Help yourself to free pancakes at Denny's, IHOP, Waffle House. I don't know. Whoever makes pancakes. Pancakes should be free on your birthday. That's like global rule. So if they make pancakes, make sure you get some free ones. Motion for channel-specific birthday emotes. I don't even know what that means. Like a cake with RA on the top? I don't know what that would look like, Kaylee. I'm intrigued. Happy birthday to all emojis. Oh, like a gavel smashing a cake or something. I mean, there's a lot of birthday emojis. We've got cake, the party. We've got the party horn sound. Birthday emojis. Are these not the birthday emojis? Do I not know what an emoji is? This is my question. We've got the pancakes, we have the cake, we have the balloons, we have the party, the confetti, the streamers. What are we missing? Channel specific. Make your own birthday emojis like these. Oh, okay. Ashley. Okay, first drum solo. Hang on. Ready? Drum solo. There we go. All right. Happy birthday to everyone who's celebrating. Make your own birthday emojis like these. Okay, so I will tell you with most of these, I had suggestions that were sent in on the burner phone of people who made their own art. Okay, it can't be something that somebody else owns, but made their own art with a suggestion. So like a pancake stack with a dancer popping out. Dancer can be wearing a judge wig. There we go. I realize we have 48 by 48 pixels to make these out of. It is very difficult to have any sort of detail on the emoji size that YouTube gives us. Cash Baby could go away. So we could get rid of Cash Baby. But give it some thought, and if you make the proper suggestions, realize that it just has to be, the more you fit in the picture, the less it will look like what you want it to look like. I've learned that the hard way. Good morning. Good morning. We are 2 hours away from Robert Tellis, so we're going to probably, I wanted to jump down to Heavenly Wood. You guys know Heavenly Wood. It's Judge Wolfe. If I can see if I can pull him up here. Let's see. Hey, Judge, how you doing? He's doing a criminal docket today, so should have a couple things on the schedule.
Judge, next up's going to be
Program out there. There we go. See if he got his mic fixed from yesterday. Oh, the gate comparison. Let me talk about that. I went to grab all the video, and I found out the 48 Hours had already done this exact thing, and they already had the perfect videos. I might be able to show you just a segment that I pulled from there. Let me, just one second. I've never seen him quiet this long. Oh, new inmate.
What now?
Like you asked, we went ahead and bumped it up so you can go ahead and get it put into effect and knock it out. Go ahead and sign here. This is saying you understand you can have a hearing at that later date, but you were giving that up. And in order to put it in effect, I've got your jail credits already noted on here. I'll give you a copy.
Did he say what now?
Sign right here.
Oh, the credits from last year too?
Yes. Oh, awesome. Yeah, you're getting all the credits.
Hold on
the
just a
pre-trial
second, Mr.
credits,
Hunt.
everything.
I want all the jail credits. Credits from last year too? Awesome.
So don't jump under the bench or try to run outside the courtroom. Everybody hear that? There's the fire department's running a test, so there may be a siren that goes off here. Try to stay calm. So.
You can have this for your honor. This isn't official.
Right.
It's just a draft.
Mr. Davis, have you placed him under oath?
This is going to get so
Mr.
loud.
Davis, raise your right hand. Let's place you under oath.
Yes, I do.
State your full name for the record.
Judah Isaiah Davis.
Mr. Davis, you are here today on a charge of violation of probation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty to this charge, to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes.
We have an amended violation of probation, which really is academic, but do you wish a formal reading of that charge?
Wait, formal reading, Your
So
Honor.
formal reading is waived, and we're going to dispose of it under this agreement as well. If we had that hearing, you would have the right to have a lawyer and to have one appointed for you. Do you understand that?
Yes, sir.
And at that hearing, the state would be required to prove to the legal standard you had violated your probation. But if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that?
Yes, sir.
You understand that by pleading guilty, you're waiving your right to a hearing and to the appeal. All I'm going to do is revoke you to put your sentence into effect with credit for all your time. Do you understand that?
Yes, sir.
Is that what you wish to do?
Yes, sir.
All right, and upon your plea of guilty, I find you guilty, or that you are revoked to serve your sentence with credit for all your time. And Mr. Stevens has put all the dates of your incarceration that you're entitled to credit for here on this document.
It's a list.
All right, thank you.
Apparently he's a repeat offender with a neck brace. Give me a second. I'm working on the excerpt. I have to pull audio from it.
Do we want to go ahead and have them turn the jail camera on?
Ooh, jail cam.
Okay. Who do we have here? All right. Yes. Oh, if this needs to be off the record or on the record.
He muted us. Okay, I might have made a mistake, but I just chose to update DaVinci Resolve. So it's going to take just a minute here while we update the editor. And it's taking its sweet time. That'd be a huge update, too. Dreama Landry gifted a membership. Thank you very much, Dreama. Appreciate that. Jail cams like a trail cam. Only they're more secure. Trail cams can get stolen. Jail cam cannot. It's locked away.
Mr. Elliott is here on your motion to withdraw, Mr. Stevens, and it's my understanding that this is part of that conspiracy case with multiple defendants, and there are several defendants who have yet to be served with a indictment. And as a result of that, after examining the names of those individuals, your office has discovered that you would have a conflict in representing Mr. Elliott. Am I correct?
That's correct, Your Honor.
Mr. Elliott, I'm going to need to appoint new counsel for you.
Conspiracy case with a whole bunch of defendants. Mr. Wolfe, Judge Wolfe, what do we have going on here? Is this like a Young Thug 2? Oh, yeah, the update is 5.6 gigabytes.
So these are the only appointed ones?
They must be being tried. Well, lots of defendants. They must be tried together. That's how you have
All right, I'm going to appoint Ms. Marion Fordyce to represent this defendant. Ms. Fordyce is a lawyer out of Cheatham County. She's an experienced criminal lawyer, and so I will appoint her to represent Mr. Elliott, and we'll reset this matter for December the 12th for status. He has a trial date, though, of, I'm sorry, this is a trial date of October the 29th, so this is a different scenario. Is that my date? Well, is this is one of the 26 different conspiracy cases? Okay. All right, then we'll leave it set for
How many
status
conspiracy cases
and
are
plea
there?
on 21st of October. Trial date will remain October the 29th. We'll let Ms. Fordyce have an opportunity to get involved in the case and then go from there. All right, thank you. Sorry. I didn't think there were enough. I think there were. Everybody stay calm.
Everybody, nobody move. Nobody move. Deep breath, everybody. It's okay. It's okay. It's just a test. The strobe light is going to turn off. You're doing fine. You're doing fine, everybody. Deep breaths, everybody. Deep breaths. Were this an actual emergency, the instructions would follow and tell you what to do. But right now, just stay calm. Just stay right here. My nerves. I can't handle it. The inmate's like, does this mean I can leave? No, you have to stay here.
Mr. Spratt's case, is that correct? Where do we lose Mr. Spratt?
Okay, now, we all love our firemen, right? Firemen, they're always the heroes. Let me just put this out there. This is a test of the emergency broadcast system. No. Let me just put this out there. Run, save yourselves. You guys are funny. Firemen, don't they like work 24/7? Wouldn't it be possible maybe to run this drill, I don't know, like 10 o'clock at night? Or instead of, now?
Mr. Godwin's case, I only saw one on the docket. I think there's 4.
Is it just
Right now,
echoing in
we're
my
still set
head?
for trial.
or-
I think he has that September 9th plea date as well.
Yes, we previously had already set a September 9th for the final plea date, but he has trial dates of September 19th and 20th, and that is a go on those trial dates.
Is your, I mean, the court would still take a plea on September 9th, is that?
We'll take a plea on September the 9th. After that, it'll go to trial or plead to the indictment.
Okay, thank you, Your Honor.
Judge, I've been advised.
At what?
I still hear it echoing in my head.
Your Honor, I'd like to take it up. I can. On page 11 of your docket, Your Honor, State versus Eric Grove.
Right.
He is set to go to MTMHI for an assessment. I need another date. If you'd like to have the December 12th date, that's fine with the,
We can just put him on December the 12th along with all the others.
yes, sir.
Do not need Mr. Grove then.
Yes, sir. Thank you.
Judge is going to order that alarm turned off here in just a minute.
At least we know if there was a fire that they actually work. So
There's always a bright side. Silver lining. And good news as well. We're halfway through the download for the DaVinci Resolve update. 3 gigabytes have come through so far. You can hear it echo throughout the courthouse. All right, let's proceed, Judge. I think they're done.
Can you reach up here?
The reason he asks is he's got belly chains on, I think.
What we talked about yesterday.
all right, I've been handed a document indicating it's going to be a plea to the violation of probation. Mr. Hamilton, raise your right hand and be placed under oath.
Yes.
State your full name for the record.
Alexander Hamilton.
Mr. Hamilton, you're here today on a charge of probation violation. Do you understand that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
Do you understand that you would have the right to have a lawyer and to have one appointed for you if you could not afford your own?
Yes, sir.
Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of guilty to the violation of probation, you're waiving your right to that hearing, to that appeal, and all I'm going to do is to go ahead and approve what your lawyer has worked out, and that is basically you're being sentenced to 5 years community corrections, and that's restarting your sentence, in other words, to 5 years, and that you're going to have weekly drug tests with zero tolerance drug screens, and you're undergoing an alcohol and drug assessment and following all treatment recommendations as a result of that alcohol assessment. You understand all that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you wish to enter a plea of guilty to the charge of violation of probation and waive your right to that hearing?
Yes, sir.
And upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence, but I will by agreement of the state and your lawyer, restart your sentence of 5 years on community corrections today. And as a condition of your new sentence, you'll have weekly drug tests with zero tolerance on drug screens, and you're to undergo an alcohol and drug assessment, follow all treatment recommendations. Good luck to you. This is a one-time deal. You understand that, right?
Yes, sir.
Your Honor, to let community corrections know, he's got a hold on him out of Hickman County. We anticipate he'll get that settled pretty quick, but
All right.
he won't be able to report this week. Thank you, Your Honor.
So here's the big question. Isn't it more likely that the people won't respond properly to the fire alarm than the fire alarm won't go off properly? I mean, if we're just changing batteries, okay, that's pretty simple. Should we not also just have the people test their fire alarm response?
Sergo, I saw your motion to declare the case extended and complex, and I saw that the first case on the docket was driving on a revoked license, so I was wondering exactly how complex a driving on a revoked license was, but I turned the page and saw the other cases. So.
Tell us, Judge. Spill the beans.
All right, Mr. Sergo, you have Mr. Harding here.
Yes, Your Honor. There's actually multiple cases I was appointed to. One of them was resolved. The others are pending. It's the, I believe it's 11 count indictment. There's 27 co-defendants.
Oh.
Discovery took 3 to 4 terabytes. We've had motions. It's to the point now where we're either going to have to enter into a plea agreement or prepare for trial. And that is why I've asked for the case to be.
I agree with you. I think that is legitimate on that particular one. So you have an order prepared?
I believe my office has submitted an order to the court, and if not, I'll have it forward.
Wow.
So what are we doing as far as disposition? Are we resetting this along with the other? I assume you don't have a resolution on that conspiracy case?
Not at this time, Your Honor, and I believe the court has mentioned December 12th. December
the 12th is the date, the last plea date for all of these cases, including the conspiracy. And when that happens, we will be in a situation where we're going to set a trial date for whoever has left on that conspiracy case, and we'll find a venue large enough to accommodate that, and then we'll try those cases all together if necessary. But once it goes past December the 12th, it's either plead to the indictment and go to sentencing or go to trial. So we'll set it for December the 12th to see if you can work it out.
I appreciate that, Your Honor.
Thank you.
And if it pleases the court, that completes my business. Excuse
you may.
Thank you, sir.
Okay, I need to see Judge Wolfe preside over a 27 defendant was it conspiracy case? How many counts were there? 11 count indictment just for that defendant?
Did you have an order in that file, Mr. Sergo? All right, that's fine.
Okay,
Mr. Sergo, out of an abundance of caution, why don't you submit another order for on your motion to declare it complex and extended? Would you do that for us, please? All right.
I think of all the people to train the public to not respond to fire alarms. The fire department.
At the jail, can you hear me okay?
Place.
Yes, Your Honor. Do have my sincerest apologies for the tardiness. Do have a question. One of the inmates on the Zoom docket that we had, Mr. Banks Jr., Corenzo Banks Jr., he was there in person and was sent back, I believe, reset. Are you going to need to see him on Zoom?
We will not need him on Zoom, I don't think. We've reset him for December the 12th.
Understood. The first one you want is Mr. Bolstad?
All right, the Bolstad. I'm going to take care. What I'm going to do, so that you understand, is we have inmates here, and I'm going to take up an inmate here when we have one, and when we don't, I'll come to you and get your inmates, okay?
Yes, sir.
Try to expedite things.
Absolutely.
So right now I've got someone before me, but if you want to go ahead and get Mr. Bolstad in the room there.
Be glad to, Your Honor. I'll go ahead and mute it.
All right, thank you. How do we, who do we have here?
Your Honor, on page 14 of you. Yes, sir.
All right. Mr. Haywood on page 14.
Yes, sir. On 20, CC 24, CR 50. Mr. Haywood appears before Your Honor. We would ask to move this to, I've explained to him that there are no more trial dates for the year. We would ask to set this on that December 12th docket, Your Honor.
December the 12th. What I want you to understand, Mr. Haywood, is that it will be the last day for you to try to resolve your case by any sort of plea agreement. Not saying you should. I'm just saying that'll be the last day for that opportunity, because on that day, if it is not resolved by an agreement, I'm going to set a trial date sometime during the year of 2025. And when it gets set for trial, you'll either go to trial or you'll plead to the indictment and go to sentencing. You understand that?
Yes, sir.
All right, December the 12th. All right, at the jail, this is Mr. Bolstad. Mr. Bolstad's good morning. You're represented by Mr. Flanagan, is that correct?
Yes, sir.
Have you had any do we have any idea where Mr. Flanagan is?
It wasn't my turn to watch him, Judge.
Hold on, Mr. Bolstad, while we round up your lawyer.
All right.
Okay. So he was in a Zoom hearing somewhere else.
Mr. Hedge, come here, please.
How dare he?
So as we discussed.
Mr. Bolstad, if you'll just remain quiet, I'm going to take up a matter here in the courtroom while they look for your lawyer, okay?
Yes, sir.
And we will find him. We're good at finding missing lawyers.
I'm going to guess it's Mr. Nathan Owen Hedge.
Yes, sir. Down there. I'll get it.
All right, I've been handed a document indicating Mr. Hedge is going to be entering a plea of no contest to count one, an amended charge of simple possession of marijuana, and to receive a sentence of 11 months and 29 days suspended on time served to supervised probation, $250 fine and cost. Count two, unlawful drug paraphernalia, 1129 suspended to supervised probation, $150 fine and cost. Those will be served concurrently. Any items will be that were seized will be forfeited, and it would be concurrent to a general sessions case that's indicated on the document. Count three would be dismissed. Mr. Hedge, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record, please.
Nathan Owen Hedge.
Mr. Hedge, you're here today on an indictment charging you with 3 different counts of violation of the law. Have you seen or been shown a copy of those charges? Talk them over with your lawyer. Discuss with him the possible sentences you might be facing, as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest. What that means is you understand what the state's evidence is. You're not going to admit you did anything, but you're not going to deny it. And the state's going to then tell me what their evidence would be if this case went to trial. Do you understand that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and have a speedy and public trial on all charges in this court?
Yes, sir.
Do you understand that if you went to trial, you'd have the right to have a lawyer until have one appointed for you, as I've done with the public defender?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading no contest, you're waiving your right to a trial and to an appeal, and all I'm going to do is to approve what your lawyers worked out? Do you understand that?
Yes, sir.
Do you understand that's going to result in a conviction, 2 convictions that are both misdemeanors, but they'll be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest and waive your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
You understand I have to have facts presented to me that will allow me to find you guilty under this agreement.
Yes, sir.
Then I want you to listen as the state tells me what their evidence would be if this case went to trial. General?
If this case were to go to trial, the proof would show that on or about January 4th, 2024, Agent Freeze in DTF observed the defendant driving here in Dixon County. He was stopped for a taillight violation. Subsequent contact revealed plain smell of marijuana protruding from the vehicle. A search produced marijuana and scales in relation to where the defendant was sitting.
All right, Mr. Hedges, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be at trial?
Yes, sir.
You still wish to enter a plea of no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Stevens has done a good job of representing you competently?
Most definitely.
Mr. Stevens, you know of any reason you should not enter this plea?
I do not, Your Honor.
Then Nathan Owen Hedge, in docket number 24, CR 51, upon your plea of no contest, I find you guilty of count 1's, sentence you to 11 months, 29 days in the county jail, suspended on time served to supervised probation, and you're ordered to pay a $250 fine and costs. Count 2, you're found guilty, sentenced to 11 months and 29 days, supervised probation, $150 fine and costs. Those are both served concurrently with one another and concurrent to your general sessions case. Any items that were seized are forfeited as a part of the agreement, and count 3 is dismissed as a part of the agreement. You'll need to see the probation department. Any word on where Mr. Flanagan is? Okay. Do we need Mr. Bolstad?
Yes. We need to bring him down.
All right, Mr. Bolstad, we need to have you brought down from the jail to here to the courtroom. So if at the jail, they'll put you on the bring down list, okay? We'll probably see you after lunch. All right, thank you.
Okay. I've got the video set up. I just need to figure out how to make it go full screen.
Your Honor.
Yes.
Did Mr. Flanagan, is he down there? I have 2 others that.
I'm sorry, he's been brought down, and we'll probably have him brought down. If you can bring him down before lunch, that would be fine with us.
Yes, sir. We've got the court van should be coming back up, but I've got 2 other Mr. Flanagan's clients here. That's why I was asking.
Let me see if I can find that out. Mr. Wainick, would you ask Mr. Flanagan if he wants all of his clients brought down? Let me see if I can get you an answer on that, okay?
That's fine, sir. I'll move on to a different attorney counsel for the next.
Okay, so we're going to hold on for just a second. I'm going to show you the walk, the side-by-side walk, really quickly. I think it's on channel 8. This is what I promised you. We were going to get the walk from the defendant, Robert Tellis, where he has a distinct gait. This video was shot by RJ, Review Journal, as part of the interview that they did with him in his office. And so they have this with him walking, and then we've put it side by side with an image of the assailant walking. And that sort of, look at the arm hanging down, look at we're just looping through it a couple times, but . What do you guys think? Is it a match? Is it matching up? Or is it just another person walking? Yeah. Anyway, that's what we got. Let's go back and watch the rest of Judge Wolfe here.
Did you get that? Because he's going to have new charges coming out, we'll need to arraign him on the 10th, but
Yes,
we'll
sir.
have him on the 25th if you don't settle it on the 10th. Okay?
Yes, sir.
All right. Okay, at the jail, if you'll unmute. Are you Mr. Greer? What's your name?
No, sir. I'm Mr. McCoy.
McCoy, okay.
Like Hatfields and McCoys?
All right. Do we have any word on Mr. Broman? This is one of the conspiracy charges, is that correct? Have you heard from Mr. Broman?
Yes, sir. Yes, I spoke with him this morning.
All right.
Conspiracy charges.
We assume you do not have an agreement on your case, is that correct? You don't have anything worked out?
That's correct, Your Honor.
All right. We're going to reset you for a final plea day on December the 12th. We don't have any trial dates available for the rest of this year. But on December the 12th, if the case is not settled, then I'm going to assign a trial date. And on that trial date, you'll have to either go to trial or plead to the indictment. There won't be any other settlement agreements accepted by the court. Your last chance to settle the case will then be December the 12th.
Yes, sir.
All right. Thank you.
What's this conspiracy? Can somebody find me the news on this? Mr. McCoy's in on it? Conspiracy theory?
Say anything here.
You think he's on the conspiracy too?
Who is?
Your Honor, this is Mr. Eric Grove.
All right. So that everybody understands, I'm switching back and forth between the jail and here. So who do I have here?
Tell me your name.
Eric Grove.
We announced
Eric Ryan Grove.
I
Okay.
believe for that December date, he's got to have some additional evaluations.
And that's Mr. Grove's?
Yes.
I didn't get a chance to hear you. Some additional what?
All right, we're going to have some additional testing performed, Mr. Grove, so we are setting you for a future date of December the 12th to try to see if we can get your case resolved. If not, we'll set you a trial date on that day. December the 12th. Thank you.
Thank you.
All right. Okay, that's fine.
No trial dates till the end of the year. This judge has complained. Judge Wolfe has
I'm
complained
just
over and
getting
over
into
about
a little bit
how
of a
busy he
who's
is.
on first and what's on second situation between the jail and here.
Little Abbott
So
and
when
Costello.
you call out somebody's name, shout it out loud and clear like that fire alarm so that I make sure I hear it.
Judge Wolfe is overworked. He works multiple counties. He travels around, basically never gets a day off. And he actually went and spoke at the legislature speaking for additional funding so he could get some help. I don't know how that went, but it's a good judge. And if they work him to death, they'll have a huge loss. We have a man bun.
At the jail, what is your name?
Greer. Richard Greer.
Richard Greer? Alexander Hamilton? McCoy's? What do we have here?
All right. You're represented by Mr. Flanagan, who's here, and he is in the middle of another hearing in another courtroom, so we're going to pass you, and he may want you to be brought down. If he does, we'll let you know and bring you down so that he can resolve the case.
Okay.
Thank you.
Yeah, if we have a Hatfield, that'll be like a blackout.
All right. I've been handed two documents in docket number 23 CR 99. Upon his plea of no contest to shoplifting, he would be found guilty, sentenced to 11 months and 29 to serve. That would be concurrent with the next case and with his Williamson County and Hickman County cases. As a part of this sentence, he would be banned from going back into Walmart, and he would be ordered to pay restitution of $229.80 to Walmart and the court costs.
In front of the Walmart.
In docket number 23 CR 100, upon his plea of no contest to count 2 of the indictment, he would receive a sentence of 10 years Tennessee Department of Corrections to serve, a $2,000 fine and cost. Count 3, sale of a Schedule 2, a resale of a Schedule 2, a Class C felony. He would receive a sentence of 10 years, the Department of Corrections, as a $2,000 fine and cost. That would be concurrent to count 1, and those would all run concurrent with Williamson County and Hickman County cases. He would forfeit all seized items to the Drug Task Force, and if he is eligible, he would receive treatment in prison. Of course, that's the Department of Safety that has that, Department of Corrections, rather, that has that jurisdiction. Counts 1, 4, and 5 would be dismissed, and he would get pre-sentence jail credits according to what are set forth on this document.
This inmate seems to be well-traveled.
I believe count 2 was a B felony on the indictment. He's pleading to an amended C felony.
All right. It's set out here, methamphetamine count 2 is a C, but it is a B felony. He's sentenced as a range 2 offender as well. Mr. Perry, raise your right hand. Let's place you under oath.
He gets a B instead of a C. Lawyer instructed the client.
State your full name for the record.
Incorrectly.
Weston Patrick Lee Perry.
Mr. Perry, you're here today on a number of
Mr.
different
Perry.
charges. You've heard me go over what those charges are, but I want to make sure that you understand your rights on all of the charges. Do you understand that what you're charged with in each of these cases, and have you seen or been shown a copy of those charges? Talk them over with your lawyer, and you and Mr. Howard have an opportunity to discuss the range of punishment you're facing, any possible defenses you might have to the state's evidence.
Yes, sir.
Well, it's indicated you want to enter a plea of no contest. What that means is you understand what the state's evidence is. You're not going to admit you did anything wrong, but you're not going to deny it. And as a result, the state's going to tell me what their facts would be on each of these cases. And I'll use those facts to find you guilty according to this agreement. Do you understand that?
Yes, sir.
You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury.
Yes, sir.
You understand you would have the right to have a lawyer and to have one appointed for you if you could not afford your own, as we've done with the public defender.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify in your own trial.
Yes, sir.
You understand you and your lawyer would have a right to confront and cross-examine all witnesses the state called, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer's worked out. You understand that?
Yes, sir.
But do you understand that's going to result in a number of convictions, and those convictions are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime?
Yes, sir.
Now, you understand I'm sentencing you to 10 years on these felony charges. How much of that time you serve is up to the Department of Corrections. As far as I'm concerned, you're getting a 10-year sentence to serve every day. The department will be the one to determine what credits you get towards that. Any credits or pre-sentence jail credits are the only thing that pre-sentence jail credits are the only thing that are a part of this agreement. Do you understand this?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest and waive your right to a trial and to an appeal according to this agreement?
Yes, sir, I do.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I can't accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty.
Yes, sir.
Then I need you to listen as the state tells me what their evidence would be if this case went to trial.
Judge, in regards to 2023 CR 99, Mr. Perry did on February the 19th of 2015 go into the Walmart, remove items from their package, and then place them underneath his clothing and leave the store without paying for them. On 2023 CR 100 on February the 28th of 2023, there was a traffic violation that took place. Agents with the task force stopped a vehicle in which Mr. Perry was the passenger of the vehicle. A canine sniff took place on the vehicle with an alert. There was a search done, and there was a backpack recovered at Mr. Perry's feet that involved a large amount of methamphetamine as well as a resale amount of fentanyl.
All right, I'm not asking that you agree with all of those facts, but do you understand that's what the state would prove at trial?
Yes, sir.
And do you wish to plead no contest still?
Yes, sir.
Are you satisfied with your attorney services?
Yes, sir.
I feel like Mr. Howard's done a good job of representing you competently.
Yes, sir.
Mr. Howard, do you know of any reason you should not enter these pleas?
No, sir.
Anything further from the state? Then Weston Patrick Lee Perry and docket number 2023 CR 99, upon your plea of no contest to shoplifting, I find you guilty, order that you be sentenced to serve 11 months and 29 days in the county jail. That will be served concurrently with the other charges that I've already set forth. You'll be ordered to make a $229.80 restitution to Walmart, and you're banned from going back into Walmart. Count 2 of that indictment is dismissed, and the pre-sentence jail credits are set forth on that document. Docket number 23 CR 100, you're found guilty of count 2, sentenced to 10 years in Tennessee Department of Corrections to serve as a range 2 offender, a $2,000 fine and cost. Count 3, you're sentenced to 10 years Department of Corrections, a $2,000 fine and cost. Those two are concurrent with one another, and both counts are running concurrently with your Williamson County cases and your Hickman County case that is identified here on this document by the docket numbers. You are forfeiting all seized items to the Drug Task Force. If you're eligible for treatment in prison, then the court will authorize that treatment to the extent that I have any control over it. That's the judgment of the court in the case. Thank you.
Thank you.
Man. Tennessee's got some hardened criminals.
I can do it right now. So let me get this guy at the jail and then we'll take a break. All right, I'm going to take up this inmate at the jail and then we'll take our mid-morning break. Who do we have at the jail?
Marty Mackin.
This is my client, Mr. Marty Mackin. He has a VOP. We may have a resolution in his case. The general was going to make a phone call during the mid-morning break to see if we could.
All right, Mr. Mackin, your lawyer's working on trying to resolve your case, but they need to make a phone call, and I've been requested to go ahead and take our mid-morning break to allow some of these things to be dealt with, so we're going to come back to you after our mid-morning break. Is that
if it pleases the court, could he be brought down? Is that possible, Mr.
I guess
Howell?
I'll be later this afternoon, but that's fine. I'll be here for a while.
Judge, like I've got
You don't have
nothing.
any place else to go, do you?
Nowhere, Your Honor.
All right. We'll take we'll probably bring you down, Mr. Mackin, if your lawyer gets something worked out.
All right, thank you.
We'll stand in recess for 15 minutes.
All right.
Judge heads off to his chambers to get some much needed R&R, maybe a little bit of shut-eye. You never know. Could happen. Let's see. We have a couple more things going on. We've got Judge Boyd down in Texas we can jump to as well. All this we're waiting for our trial to start because we're on Pacific time. Looks like that one's not going to start until, 11:30. So we'll be over there about 11:15. So we've got about a little under 2 hours left. I do have the placeholder set up for the new trial in case you want to hang out there and watch nothing while we wait. But we've got that there, and we'll portal over to it when it's time for that court to start. Let's see, where's Judge Boyd? Where are you at? Right there.
Relation of testimony and stipulations with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
I'll check and see if there's anything in Thurston. Thurston's in Washington as well, so it's a West Coast trial. It usually doesn't have much going in the mornings, but we'll check that in just a second. Bite Me gifted a membership. Thank you very much, Bite Me. Appreciate your generosity. Rebecca's been a long-time supporter on the channel. Let's see. Let me check on Sarah. I think Sarah Boone's, the last update on Sarah Boone was that her next hearing was sort of canceled for some reason. They've been scheduling like weekly hearings there. Let me check and see what else is up with her. Defendant's awfully smiley for the judge reading a list of her wrongdoings. Thank you, Rebecca, for the update. Buttercup, give her a pat for us. Apparently there's a lot to read. The latest in Sarah Boone that I know is that the evidence view is going to be happening probably at the sheriff's office, not in the court, so it's not open to the public. That's something that
All right,
Sarah
after
wanted,
reviewing
but-
states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, my client has no criminal history. She works for the U.S. Attorney's Office, is that correct? And she's been there for
10 years.
10 years.
Wow.
She is an upstanding citizen, and she made a mistake with a
Not made a
teenager.
choice.
Absolutely. She made a choice, and she understands that and is accepting responsibility for her choice, and we just ask that you follow the plea bargain, Judge.
All right, so what happened?
We were at a volleyball game, and the child came. It all started off with the coach, and the coach's child was bullying one of the other kids, and I went down there to break it up. And anyway, the girl called me a bad word.
Mm-hmm.
So my husband at that point got up. We got up to leave, and I was talking to one of the parents, and well, they got up and they left, and they came through where I was standing speaking to the other parent. And I made a bad choice.
Okay. All right.
Because she did call me another name again.
I understand. So you just can't do that. You understand?
You can't just smack a
And
kid
I
because
see
they
the
deserve
game
it.
was forfeited because a lot of parents just left.
Yes.
All right. And the complainant, she's not related to you at all? This is the coach's child?
No, this is just another girl that played on the team.
All right. Well, I don't know when people will address bullying. My mom would address it head on. All right.
Well, I got in trouble for it.
Yeah.
And just one more thing. The other concern is my client's daughter still does play volleyball. And so I believe there is the possibility and likelihood that they will be at the same volleyball game. She understands she's not to talk to this child. She understands she's not to, sit next to them.
She's just going to have to drop her daughter off and wait in the car.
Okay.
Sometimes these are consequences for our actions. So she'll have to drop her daughter off. And if anybody's being bullied, report it. And if that doesn't do it, because I'm assuming these are organized sports.
Yes.
And they have higher ups. If there's an issue with the coach who's allowing the girls to bully each other, then you need to go above his head, or as they say, go above his pay grade. And sometimes when you throw the words in, well, I guess I'll have to get an attorney. That's usually when people stand up and listen. So if you put it in writing, I'm not telling you what to do, but I would put it in writing and say, this is what I witnessed. There's bullying going on. The coach is not addressing these issues. I guess after you, my next step is to contact my attorney. Then usually people pay attention. And I would also suggest that you tell them that you want to see their handbook, because they should have a handbook. All the organized sports are supposed to have a handbook like the schools do, what their rules are. And that way, when you send whatever letter you're going to send, you can go to a specific rule. And if they don't have a handbook, then they should. All right. All right. Do you all want to speak of length of probation?
Again, Judge, my client is an upstanding citizen who's been a government employee for 10 years, and she's never been in trouble before. She is motivated, understands what she did was wrong. She is motivated to do anything that you ask of her, and we ask that you follow the recommendation from the state and keep it at 1 year probation.
The 1 year's our recommendation.
Oh, see, but defense, since you told me to keep it at 1, I was leaning towards 6 months.
We're okay with that as well, Judge.
Well, you're gonna make an argument.
I reiterate all of my previous arguments, Judge. She will be successful, and I think this was a one-time mistake, and I think 6 months is sufficient.
Okay. That just turned on a dime. We should bring Mr. Cox in here. Mr. Cox, you want to join in the argument? State.
And I do have to tell you, the child I was defending was not my child. It was another child.
No, I appreciate when people step up. I think we all owe a duty. It really takes a village to raise children. My motto is always, if you see something, say something, not, act physically, unless you have to, because there's no one else around.
Don't say you have
all right.
to. Ma'am,
State, I know you're asking for 1 year. Do you have any objection? It is a misdemeanor. She doesn't have any priors. At least that's what's being presented to me. There are underlying circumstances with why this happened. Is there any objection to the court going below your recommendation for the community supervision?
In the courts.
All right, thank you. All right, and then of course, if you are unsuccessful or if they feel it needs to be extended, it can be extended up to 14 months. You understand? Oh, wait a minute. Okay. Well, actually more than 14 months. You can be extended for 2 years, okay? All right, this is what the court is going to do. The court is going to sentence you to 6 months deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with the complainant.
Lawyer's like, you don't work with minors, do you? Nope.
If there are still volleyball tournaments, which I'm being told there are, you're just going to have to drop your daughter off. You understand? And wait in the parking lot.
Okay.
And you can always do the audiobooks in the parking lot. There's always something to do.
And Judge, she does live in Brewster County. If we can transfer to Brewster County.
Where's Brewster?
Alpine.
Where's Alpine?
These were my questions, Judge.
Have you ever heard of Sorrel State University?
Where's Sorrel State University?
Big Ben.
Okay, Big Ben.
Yes.
All right, awesome. So Brewster, can you spell that? I don't want to mess up.
Mini Duck, what's the case about? Courtroom for
EWSTER.
Oh, it's like the Women of Brewster Place. Okay.
Who are the women of Brewster Place?
Oh my God, you should be embarrassed for saying that. Although Zach doesn't know either. So
Thank you, Zach.
I got you.
There's going to be a transfer to Brewster County. I'm going to order anger management.
Parenting classes.
Probation, is there anything else she needs?
Parenting classes, Judge? This is your opportunity.
All right. Is there anything else you need from the court to be successful on this probation?
No.
And you got off light. Those parenting
All right.
classes
I'm going to show
are a
you what's
doozy.
entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. I am not going to be the judge that is supervising your probation. Of course, probation technically was supervised, but if there's an issue with your probation, you'll have to go to the judge that sent this case to me to accept your plea. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you so much.
Thank you.
Thank you.
Everyone, is probation going to give her conditions here, or is she going back to the 227? All right, who needs the report?
I'll give it to her. Thank you, Judge.
All right, well, that needs to go back to the 227. Clerks, do you all keep that? Oh, excuse me. Oh, the clerk said is their paper.
All right, never mind.
All right, thank you.
All right. Yeah, apparently you can't mouth
All right,
off.
who's
You
here
can't
on
smack the
Keisha
mouthy
Hullaby?
kid at a sporting event.
What is this?
I thought that was just a known rule, but
Your Honor.
Oh, sorry, this goes with that as well.
Your Honor.
Yes. Keyshawn? Kishana. Who's the attorney for Kishana Hullaby?
Bridget Garza. Oh, she had to go to the 226. They called her.
All right, do you want to step in and take the plea for her then? It's deferred.
Well, I think I'll defer to her.
All right, thank you. All right, so we'll wait till your attorney comes back. She had to run to another court.
and we had a thunderstorm come through last night. It was a doozy. Hailing sideways. It was crazy. Lightning all over the place.
All right, who's here
I
on
think
Juan
enough rain filled up the hot tub.
Ramos?
Mini Duck, do you know what the case in Thurston County is about?
State, is this criminal trial division?
It is.
All right, Ms. Ferguson, I need a jury trial date. How long do you expect this trial to last?
2 days.
All right, it's 2 days. And it's criminal trial division. Sorry, this will be the soonest we can get to you. I see that you were set to impact. We've just finished back-to-back trials. So we're going to give you a date, okay?
Judge, given the length of time he's been in and the resets by both the state and the court, would the court consider a reduction in bond to $25,000?
All right, if you all file it, I'll consider it.
Thank you.
You're welcome. Okay.
This is a bad deal. The defendant has not done anything to delay this, and because the court's been busy, he's been pushed out and pushed out and pushed out.
All right, November 4th, is that an impact or here?
Yeah, I've got
All
the
right,
burner,
it'll
Josh.
be
Go
November
ahead.
4th in Impact Court.
At the earliest, the courthouse?
Yes. We have, I think, 3 murder cases coming up.
Whoa.
All right. Have you received all of the discovery? Did you all do a discovery acknowledgement?
I don't know if we have an acknowledgement. We'll have to check because we got discovered early, but we'll check before November 4th.
All right. Thank you. Do you have any questions, Mr. Ramos?
Oh, man.
All right. Thank you so much.
Thanks for dressing appropriately. Oh, never mind. Don't say that. Don't say that. I've got the burner. Feel free, Josh, give me a text. I'll check it out. We're about an hour and a half away from the start of the Tellus trial for the morning. Mini Duck, it's a DUI, reckless driving. I was summoned for jury duty yesterday. Mini Duck, are you on the jury? Don't tell us. Don't tell us if you are. Thurston County.
Just give me a moment. Let me check.
No, you're not on the jury.
And you said Pellegrini?
Yes,
Yes, I have that. Yes, we're going to take it up.
Okay, thank you.
All right, thank you.
I just have a few other points.
Okay, sure. And guys, what page is Juan Ramos on? All right, thank you. All right, the parties on Pellegrini.
Yes, sir.
All right, court is calling 2024 CR 007495, State of Texas versus Dennis Paul Pellegrini. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Peter Calderola for Mr. Pellegrini, Your Honor.
All right, this case was previously set.
Where's the defendant?
On August 19th, the defendant was a no-show. The court recalled it for today to have defense attorney to appear and also for the defense attorney to contact your client. The parties listed on this is Gail Calderola.
Yes, Your Honor. I'm standing in for Ms. Calderola.
All right, any objection to his standing in?
No, Your Honor.
All right, I had the deputy to make an announcement for Mr. Pellegrini. Deputy, what were the results?
I announced his name 3 times, Judge, and there was no answer.
All right, defense, have you had contact with your client?
Previously, Judge, we did have a working phone number. I have since tried to contact my client this morning. Got no response, was sent to voicemail, and I have also sent an email to my client, which I have not received a response from.
All right, and is he on a PR bond, Ms. Ferguson?
Mini Duck, was that up in Thurston County? Is that what you're saying? We love Thurston
All right,
County.
state?
It's a fun little place.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, and I would suggest calling the bondsman. Usually they know where they are.
I will give them a call. Thank
Okay,
They
thank
have
you.
a vested interest
Yes.
in knowing where they are. Awesome. Courtroom 4.
Thank you.
I don't think anything's happened with Mr. Frog. I think they just sort of like intentionally lost the paperwork and hope he doesn't show up again.
All right. Yes, this one. You're welcome. And I'm sorry, Norma, which page is Pellegrini on? All right, thank you.
Thank you, Josh. Just looking at it now. Is that case?
All right, who is here
when
on
it just took
Audrey
place, or it
Bash?
starts today? Audrey's here on her case. Oh, she brought a purse.
Does she have any warrants? Norma, can you check on cause number 2024 CR 2272 to see if there's a warrant on that case? We're just checking. Hi, good morning.
Robert
Thank
Tell
you
us
for
starts
dressing
in about an hour
appropriately
and a
for court.
half.
She was processed. There was a prior FTA, but she had processed on that already.
Okay, I just want to make sure so that she doesn't leave here and then there's an issue.
Okay.
All right, so where are we on these cases with discovery?
I believe I have all the appropriate dash body camera videos. There was a offer tendered.
Okay.
I discussed it with my client. At this moment, we're asking for some time so that I can still talk with her and go over some videos. There is a new case, a second degree unlawful carry weapon with the prior felony conviction.
Okay.
That's awaiting indictment. And I believe the offer it's a plea offer for the package deal.
Okay.
But she has some questions about that new case. I just need some time to go over that with her.
All right, how much time are you asking for?
30 days.
All right, Ms. Ferguson, if I can have a 30-day reset. All right, that will be your plea deadline date. Just have a seat and Ms. Ferguson will get the reset form to you. And we're going to check on whether or not there's an issue.
Okay, thank you, Judge.
All right, thank you. All right, there's no warrants.
No warrants.
Yes, he's out. Ready, approach member.
All right, just give me a moment.
Thurston County, Mr. Farag, I'll do a quick check of the jail to see if he's on the docket here. Or if he's in the slammer. Jail roster, Thurston County Corrections. Roster search. Farag. Nope, he's not in jail. Which I believe is where he would be if they ever caught him. Mr. Frog is still at lunch, yes. Let's see.
Oh, you mean a probation? Yes, I do not. I know Jordana from that curious. So.
All right, who's here on, Bridget Garza's not here yet? Okay. Laura Martinez.
Present.
All right. All right, and what are we here for today?
Hey, Judge, good morning.
Good morning.
It's our first setting in the 187th. My client had been in the state hospital for quite some time.
Yes.
They found her competent now. I talked to the state this morning and there's a referral to the mental health court.
Okay,
And I just wanted to put that on the record and let the court know that's what I've talked to the state about.
all right. Norma, this is going to be a referral to mental health court. How much time do y'all think it will take?
I'm uncertain how that process works, Judge.
Okay, so what I'm going to do is I'm going to give you all a reset, and Ms. Ferguson, you'll give them the form.
Yes, sir.
All right, she'll give you the form, and maybe if you take it over there and let them know you want to be put on the docket
Yes, Ron.
as quickly as possible, and that she's recently regained competency. What date, Ms. Ferguson? All right, so we'll do September 19th, but you may be brought back sooner than that, okay?
Okay.
Do you have any questions about anything?
No, I'm gonna be in jail.
Yes, but I'm gonna make sure that this process moves very quickly.
Okay.
All right, so that's why your attorney is gonna take that information because mental health court is right on the opposite side of this courtroom. So he's gonna go over there and make sure that they see you as quickly as possible.
Okay.
All right, and so it's best for them to see you in custody because that'll make it move quicker. So if they haven't started their evaluations yet, they may be able to get you this week, but probably at the latest next week.
Okay.
All right. And if you have any questions, your attorney can speak with you. And if he needs to bring you back before that time, he can.
Okay.
All right. Thank you.
Thank you, Judge.
Thank you.
So I want to bounce this off you guys. There's a case coming up out of Mississippi, a 15-year-old girl accused of killing her mother and attempting to kill her father. Apparently she invited her friend over to see the body after she killed the mother, shot her multiple times. 15-year-old girl. The court has ruled that this will be televised, that cameras will be in the courtroom, and this can be open.
Thank you.
You guys interested?
Thank you.
We'll start filing some paperwork if you are. Carly Gregg is the defendant, 15 years old. So crazy. She was found competent to stand trial. That just reminded me when Judge Boyd talked about it. So maybe if we could have
All right. Thank you.
If Amber's not busy, well, she's always busy, but if Amber's not busy,
Kashana Hullaby, and after this case, it's going to be Ali,
thanks, Adam,
Ganal, Camarillo, and Kruger. All right, court is calling 2024 CR 6687, State of Texas versus Kashana Hullaby. Could I have parties announced for the record for the state?
And Paris Ayden.
Bridget Garza.
And are you Miss Hullaby?
Yes.
Counsel, have you received all of the discovery and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Hullaby, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
Ms. Hullaby, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of assault public servant bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked The court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Hullaby, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration NIMAC number 734176, and there's to be restitution in 734176. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of repeal paragraph with your attorney?
Yes.
Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Stand in exhibit 1 and 10.
Any objections?
No objections.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Just looking. We do not have time to follow the Thurston County case, unfortunately. It's only got a couple of witnesses. Oh. It's getting hot in here, apparently. Quick, put it back on before the judge sees.
Thank you.
Come on. There you go. She's about to look up. There we go. Beautiful. She'll never know. How would she know? How would they find out? She'll never know. I was nervous. I was worried the judge was going to look up and be like, please stay dressed appropriately for court. It's like, but it was hot in here. Judge Simpson's on vacation this week. Hopefully it's a good one. Get some good R&R.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're asking the court to proceed with the recommendations of the ADA. Ms. Hullaby lives independently. Up until this arrest, she was employed with the city of San Antonio. Unfortunately, because of the arrest, she was terminated. She is currently seeking employment. She does have a supportive family. Her mom is present in the courtroom. Her mom has been present at every court appearance. She is remorseful. She just made a terrible, terrible mistake. She acknowledges her mistake. She is willing to comply with all the conditions that you impose upon her. She's asking the court to give her an opportunity. She will follow all of the court's directives.
Right. So who is Mr. Napoleon to you?
Napoleon, it's our old classmates.
All right. So why was he in the car with you?
We was going to HEB for grape juice.
All right. So what's your relationship?
With him?
Yes.
Oh, this is our old classmate. My friend already had that.
What do you mean your friend already had that?
Like that was her man. And I was just with him to wash the laundry in the back of the car.
So you're with him to watch laundry in the back of the car, but you all are doing groceries. I don't understand your story.
Oh, we was on the way to HEB, but before we got to the apartment, I just wanted grape juice. So that's how we went to HEB. That's it.
Okay. So the officers are saying they could smell marijuana. Why are you around people who want to?
Yeah, I don't have no answer to that one at this moment. Looking back on it now, maybe I should have been like, don't get in the car with it. But it just happened.
No, I mean,
It just happened.
stuff don't just happen unless somebody is forcing you to do it. So police pull you all over, and then you are kicking the plexiglass in the back of the car. What were you hoping to gain by doing that?
Then my anxiety, like in my head, I thought I was getting kidnapped. So I was like, let me get out this situation.
What do you mean you thought you were being kidnapped? They're police.
I know, but also I can't, like, yes, they're protected by the law, but I
Because I was
personally don't know
high.
the man. So that's why I was like, okay, it's just, when I get put in the, like, if I can't get up and leave when I want, my anxiety start rushing to the room. So now, oh, yes, ma'am, I made a mistake.
Now you made bad choices.
Oh, yes, ma'am, I made a horrible choice.
So here's the thing. I don't know about your anxiety. I don't know what's going on with that, but I do know if the police are doing an investigation and they put you in the back of a vehicle, you're not supposed to kick a plexiglass because then you're going to end up back here. And I know you're not supposed to hit an officer because then you're going to end up back here. And then I don't understand the using the racial slurs.
Yeah, I was mad, but that was very disrespectful because I wouldn't want nobody to call me XYZ, so I should not have said XYZ, you know?
All right. So you say you have bad anxiety or high anxiety. So are you receiving treatment for that?
No, I have no insurance with the city. I would love to get treated to see, because I feel it now, like my legs get weak. It's like, it's not a bad anxiety. I see real anxiety attacks. I don't think I get anxiety attack. I think it's something else because my heart be coming out my chest.
Okay. All right. If I could speak to her mother for a moment, because I'm trying to figure out what's going here, what would be the best conditions of probation for her. So if you'll step to the side a little bit.
Dan McMillan, thank you very much. 12 months. Dream of Laundry, thank you for gifting the membership. Also, we've got Bite Me gifted a membership, and just
Hello.
Beth, welcome to the gallery.
I'm doing okay. I like your shirt. That's the Scooby in, but with Bugs and everybody. We will watch that show all the time. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, if you can lower your hand and make sure you keep your voice up so the court reporter can hear. Okay. All right, and could you state your name?
I'm Bernice Elizabeth Hullaby.
All right, Bernice Hullaby.
Bernice Elizabeth Hullaby, mother to Kishana by Renee Hullaby.
All right. So I'm going to follow the agreement, but when people are placed on probation in this court, I want them to be successful. So I don't do cookie cutter probations where everybody get the same thing. So I'm trying to figure out, what do you think she needs? She's saying she has high anxiety. Has she ever had any mental health treatment, or do you think she needs to see someone?
I believe Kishana does have anger issues. I believe her anger issues has started since she's moved out of the house. I believe that as any child that has moved out or wants to get out on their own, they make their own decisions, they make their own friends. I believe Kishana had got mixed up in a crowd that she shouldn't have been mixed up in. And as every parent,
Mom's spilling the beans.
For Sunday, so we have Sunday dinner every Sunday. I had noticed some changes, and I said, "Is everything okay?" I'm a very active mother. I try to make sure I keep in touch with my children, know what's going on with my children. I knew something just wasn't right. I had spoken to Keisha the morning of the incident. Well, let me go back. That Sunday, she had came for Sunday dinner, and I was looking at her car, she has paper plates, and my husband told her father, said, Renee, those plates are no more good. You need to go to car people and get the plates replaced. She said, she said, I'll call them. And so I think I called her on Monday. No, I did call her on Monday. And I
Talk
said,
her daughter into another charge
because I was
here.
concerned about those paper plates. She said, well, Mom, I'm on my way. I said, okay. I think an hour later, I get a call from my husband telling me she had been arrested. I didn't know the full of the story, but when we did get her out, I did get her out that day. She told me, she said, I acted rationally. She said, Mom, I panicked. I kicked the officer. She said, I said some things I had no business saying, and I just shook my head. What? I would recommend with the court, and not to hurt her, but yes, I do think that she doesn't have patience. And I don't know where's that coming from, where that behavior is coming from. But overall, Keyshawn is not a bad child. She's a very good child. She's been raised in a very good home. I felt like we raised her to the best of our abilities. I've been on my job for 20 years. We've been hardworking people. Keyshawn in middle school and high school was involved in sports. She played volleyball. She played tennis. She's very successful at whatever she does when she puts her mind into it. I think she just got into the world, and the world just influenced her to do bad things.
All right,
I'm saying that correctly.
All right, so does she live with you, or she lives by herself?
Keyshawn does live independently. Keyshawn did have to move back home, and at this time, I think what really set it off, Keyshawn was living in an apartment. She got evicted because.
So is she back at home with you?
No, right now she's on her own. But during the time of this incident, she was going to get evicted. She couldn't pay her bills, so she did have to move home. I believe that kind of set off her little anger issue because she was upset at that because she had to come home. And I did explain to her. So it happens to every child. I said, so you shouldn't be upset that you have to come home. Because sometimes you just have to come home, get yourself together, and get back up on your feet. She was able to come home and live for up to December. January, yeah. January.
Okay.
She came back and she was pretty much okay. She's in an apartment now. She's doing well. I was sad that, about she lost her job with the city.
We're still on the
because they did
first question,
background
right?
check.
Okay.
And
Right.
All right. Otherwise, now
Judge said okay several
she's
times.
not racist. I didn't raise her to be racist.
Okay.
I don't know where that slur came from, but we did have a talk about that.
All right. Thank you so much. Thank you for letting me know and giving me some insight. I appreciate it.
All the
Thank
insight,
you.
all the deets.
All right, you can come back. And I want to let you know your mother's testimony did not hurt you whatsoever. What she's told me is exactly what is in the police report. All right. Is there anything else before the court makes its ruling?
No, Your Honor.
All right. This is what the court is going to do. The court is going to sentence you to a $1,500 fine. That will be probated. Court will sentence you to 3 years deferred adjudication. Take in consideration NITMAG number 734716. There's to be restitution and NITMAG number 734176. There's to be no contact with DeAndre Napoleon. That's DIEANTRAY. Napoleon. There's to be 150 hours of community service restitution. What are you planning to do with the rest of your life?
I wanted to go to the medical field. I don't know.
All right. There's to be 150 hours of community service restitution.
All right.
That will be waived upon completion of some type of trade school or higher level of education.
This defendant's reactions are insightful, I think.
There's to be regular reporting by Zoom or in person. There's to be regular random UAs.
Parenting
There should be
classes.
anger management.
Oh, good job, Sherry Ann. You called it anger management.
And do a referral maybe to Center for Healthcare Services or see if the MIC caseload is appropriate for her. If it's not, then it's not. So referral to Center for Healthcare Services and MIC evaluation, and that will be out of custody.
I'm not sure if with
And
her
field visits
with her
one time
anxiety,
per month
if basic would be good for her.
for 3 months. And then at probation's discretion. Probation, is there anything else she needs?
She said she wanted to go to med school. I
I'm
think.
sorry? Thank you. Proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Anything else, probation? Is there anything else you need from the court in order to be successful?
No, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. We can go off the record. In this court, to be successful on probation, communication is key. If you have an issue, let your probation officer know about it. If you feel as though they're not addressing it, you can always come back to the court and we'll see what's going on. Yes.
Judge, there's just one other matter.
Yes.
If we can have her drug tested so that we can get a baseline.
Is she going to be positive?
Yes.
All right. So what are you using?
Oh, this week.
Don't do like, just weed, because you're not supposed to be using drugs at all.
Yes.
It messes with the brain. And I know some people think weed, it's fine. But then usually it ends up leading to other things. All right. Probation. Can we have her do a UA today? Is that possible? All right. So we'll do a UA today. And it's to attain a baseline. And please make sure they test her. And if her levels go up, bring her back to court. Oh, and go ahead and do a TAP evaluation, and that can be done out of custody as well. And if TAP recommends inpatient treatment, we'll start with outpatient treatment. Anything else?
Nothing further.
Thank you for bringing that to my attention. All right, they'll go over conditions with you.
Thank you.
You're welcome.
She tells the lawyer, "Thanks for telling me your client's going to test positive." It is interesting as we go from state to state and see the different approach to
Violation on the pretrial.
Okay.
marijuana.
All right, just give me a moment on that.
All right, update on the TELUS trial. We are about an hour away from it starting. So when
All right,
that kicks
and
off,
I'll
we'll
give you the
portal
holiday
over.
file in just a moment. I have to put something in the system. Zaidan Ali.
Hey, Judge.
Hello.
We were in impact court last week. We just needed a trial date.
All right. Why are you late for court?
He was waiting for me. I was waiting for him.
No, here's the thing. Court, you know where court is? Court is in the courtroom.
No, I understand that.
All right, so here's the thing. There are rules that are in place, and you need to follow those rules. I've been a defense attorney. I would tell my clients all the time, hey, you need to be in court. There's no, I'm waiting for my attorney, because guess what? If something goes down, guess what we were always taught in law school?
Does he have
You know what the number one
contacts
thing
in?
is as a defense attorney? Don't you end up going into custody. That's what they would tell us. They're like, if you walk out of the courtroom, everything is okay. So if there's an issue and you're not here, you know who's going to end up going into custody? You are, not your attorney. You understand? All right. So, Ms. Ferguson, I need a jury trial date. State, how long do y'all expect this trial to last? 2 days. It's 2 days. It's criminal trial division.
She was telling off the lawyer and the client in that. Don't say anything. Don't say anything. Unless the lawyer was giving him his ride. I don't know. Oh, look, he's all blinged out. He's got the Don't fold the arms. Judge is not impressed. She
All
glanced.
right,
She
it's
saw
going to be
this.
October 1st. That's the earliest we can get you in because we have a couple of murder trials that are upcoming.
Yeah, Judge, I have a murder trial that's set September 30th in Houston. If it doesn't go, I'll be here.
Okay. All right. We'll make note that you may have that trial. Just let us know if you're going to be in jury trial, but you need to be on time on October 1st. You understand?
Yes, ma'am.
All right. Once you sign the reset form, you're excused.
Thank you.
You're welcome.
I just want to let you know, it's just the only reason I was doing this because I was confused because we had to go to a different court.
Okay.
And then like I don't know if you remember from last time.
Impact court. Yeah.
The impact court. And so it mixed me up. I was in impact court and I was like, oh shit.
All right. So now you know. All right.
Wait
Thank
for me
you.
outside.
Outside. Leave. Do not talk to the judge. The judge doesn't want your explanation. She wants you to be on time. I've got a friend who I haven't seen in a couple months. It's an acquaintance here, good guy,
Lana,
both
no.
interested in metal detecting, and he started a TikTok channel, and apparently became a gym rat. And this guy has transitioned from.
Increase the bond or remanded her for a pre-trial violation?
Yes.
He's just transitioned to like a guy that just like ripped like no other.
She wanted to see if
Like,
the
whoa.
judge would reinstate. Oops.
Oops.
Sorry.
All right. Have you conferred with the state?
No, I haven't.
Yeah.
Before
All right.
and
Have you
after
conferred with the
is
state?
crazy.
And is she in custody?
No, she's out.
So she needs to come in the court. Is she here?
No, that's my question. Did you need her to be
Yes.
present?
She'll need to be present.
Okay. All right. Okay,
And-
come in tomorrow.
Well, just a second.
I think I need to do
Remember
a
what
metal
page is
detector
Fanal
training
on?
video.
She's not on the docket today, Judge.
Oh,
It's
okay.
because of the pre-trial violation.
All right.
So you
All right.
need her to be present
Mm-hmm.
till Thursday? Okay.
All right. Who's here? Renee Camarilla?
Sorry, Skybell. Yeah, this Telus trial being in Pacific time zone is a
But-
tough one. We don't start
All
till
right.
the day's half over.
So on this case, where are we on discovery?
Judge, I have gone through all of the discovery and I do believe I have everything.
All right. Was an offer tendered?
I was just about to discuss it when she got.
Okay. All right. I'll let you guys get back.
Sorry.
Thank you.
All right. Thank you. Just have a seat.
Want her to be on silent.
Who's here on Joseph Kruger? Oh, and Maria, if you need to take a break, just let me know.
Culperistic. Would that not be like clickbait? 10-minute guide to becoming an expert
Hello.
MD. Is that
Good
would that
afternoon.
be a good
So
clickbait title?
let me see where we are. All right. So your schedule for jury trial, is that still the case?
Yes, Judge. We were in impact last week and we got sent back here because they ran out of time before they could get to our case.
All right. And the court was previously in trial the previous week and then this week. How long do y'all expect this trial to last?
2 days, maybe 3, but I think we can get it done in 2.
All right, Ms. Ferguson, on Kruger, it's criminal trial division. It's a 2-day trial.
Yes, I would give out certificates, MD certificates, to people who complete my course. And there would be an asterisk at the
All
very
right,
bottom, in
November
very fine
4th,
print.
impact.
November 4th. Yes, Judge. We filed, but I don't think it's been accepted yet. A motion to set bond. Once those are in there, may we approach with an order and we'll confer with the state ahead of time.
Yes, and if you want to, if you'll speak with Ms. Ferguson, she'll put it on the docket. And if you bring a copy of it to me, because you know it gets lost somewhere in the system.
I think that's what happened, Judge. I filed it. I don't know what's going on. It's all messed up. But I will bring an order and I'll confer with the state on it.
Okay. All right. Awesome. Just whenever you want to set it.
All right.
Thank you, Judge.
Thank you.
Judge. You said November 4th, yeah?
Yes.
There you go.
You can become an MD. I could have a whole like playlist of videos
I'll bring it on order tomorrow. We'll chat about it.
on being a neighborhood
That's
MD.
about it. Thanks, sir.
All right, who's here on Mr. Casanova?
I was going to say metal detecting course, like how to, just general guidelines, how the principles work and how
Hi.
best practices.
Morning, how are you doing?
Good, thank you.
We were going to call it MD because that would get all the clicks for people who want to go
I'm
be a
so
doctor.
glad you and your mom had a great time.
Oh, it was so much fun. The weather up there was delightful also. It was like 80 to a high of 80. Like
Oh, that's
50s at
awesome.
night. It was magnificent. But they had mosquitoes the size of ponies out there.
Oh, the size of ponies. Did you put a saddle on them?
You what?
Did you put a saddle on the mosquitoes?
You could ride them probably if you wanted to, but I did not.
All right, where are we on Mr. Casanova?
Bite me. Apparently they need you to count some ponies.
I've spoken with my client this morning. He's provided some information to me that I didn't look into. I've gotten written discovery. I've looked at all the written discovery. I haven't gotten through the audio and the visual
All
discovery.
right, and State, were you able to tender an offer?
We were able to tender an offer at this time, but again, with of course the knowledge that council wants time to kind of have a full grasp of what's all at play in this case.
All right, Norma, in this case, if you can give me a plea deadline date in 45 days, please.
Rebecca's like, size of ponies, huh? Well, that would make me not have to use this
All right, we're going to
magnifying
come
glass.
back. And what's going to end up happening, this date that I'm going to give you is going to be your plea deadline date. On that date, you need to let the court know whether or not you've reached an agreement. If you have not reached an agreement, what will end up happening is your next setting will be a jury trial. Do you understand?
Sure.
All right, October 7th. All right, sir, do you have any other questions, sir, about anything?
No, John.
All right, thank you.
Thank you.
You're welcome.
I see Debbie's bragging about the size of mosquitoes they have. I've been in some pretty hot, oppressive places. Luckily, there were mosquitoes because it was fairly remote. But when the cloud of mosquitoes would fly over, the breeze was very cool. It was nice to have them hovering overhead.
Who's here on Joshua Zamorano?
I am good.
All right, and where's Mr. Zamorano?
He's in the box.
All right, come
He's
down,
in the
please.
box.
How's it going today, Mr. Cox? You're still in every court in Bear County?
Good. Every day is a good day.
Oh, and I saw Mr. What is his name? Mr. White. He seems to think that Arkansas is going to be doing things this year.
He says that every year.
He does.
And every year he's disappointed.
Well, he said he doesn't understand about you in Florida, but I'm not gonna interfere in that. You know, I'm just saying what we're gonna be doing. But you think Miami's gonna be doing something?
In the first game.
Okay. Daniel's shaking his head like no. Well, is Dallas gonna be doing something?
I don't have any hope for that.
Okay, we got laughter and choking. Is the Texans gonna be doing anything?
Oh, I like the Texans. I like the
That's a
quarterback.
pretty good team. I like it.
I like that quarterback.
Is Pittsburgh gonna be doing anything? Vashawn is not with us today.
Yeah, I can see
But
Judge is running
All
down
right,
all
we
the
got a
favorite
lot of-
teams.
coffee going. Deputy, who do you think is gonna be doing anything? She's like she doesn't know, but she knows those teams will not be doing anything. We're gonna see what the Saints gonna bring today.
Watch out for Baltimore.
Oh, Baltimore! I need to watch out for Baltimore.
Defendant,
right.
hold your tongue.
They got their fix their weakness. They picked up a run tonight.
Oh, well, we shall see. I think after I don't watch the preseason because that's just practice. Practice.
Just
Practice.
Not a game.
We're just talking about practice. So I will say after the first, not even after the first game, after the two games, you'll see what home cooking they're serving up. So we're going to see.
Interesting.
All right. On this case, what is happening? Why are we here?
I said it for a
Bond?
for bond. Set a bond on yesterday. I said it because for some reason a bond wasn't set on this case. He was remanded without. And the state and I had an opportunity to discuss the case.
There might have been a reason.
And we reached an agreement.
All right. Let me put it on the record. All right, court is calling Night Mag number 744844, State of Texas versus Joshua Zamorano. Can I have parties announced for the record for the state?
Yeah, you asked the bar for the state of Texas.
For the defense?
Cornelius Cox.
And are you Mr. Zamorano?
Yes, Your Honor.
All right, we are here on an application to set bond. Have you all had a chance to confer
Hey,
on a
Danny.
bond amount?
Yes, the record.
Lawyers are people too.
All right, and have you all come to an agreement?
Yes, Judge, a $10,000 bond.
That's correct.
10K.
All right, and I do see that a mental health assessment was completed. Mr. Zamorano, can you raise your right hand for me, please?
Apparently, and your left.
Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Joshua Zamorano.
All right. Have
Yes.
you ever had any prior mental health issues?
No, Your Honor.
Let me
All right.
let me mute
So
the judge
if
just
you
for a second.
are,
Hey, Danny on direct is in chat. Danny's a good friend of the channel. Managed to meet up with her up at the Corey Richards hearing. We might bump into each other again if you're at the next one here coming up, the 3-dayer. If you haven't checked out her channel, she's awesome. She's a very fun lawyer to listen to as she breaks things down. Local here to the area I'm in right now, which is in Utah. So I do recommend giving her a follow and checking her out. Thanks for hanging out here, Danny. I think you're following the same case as us right now with the Robert Tellis as well. Is that right?
used any type of drugs in the past?
Way in the past.
And what would that be?
Way in the past. It's been like a month.
How far did you go in school?
Completed 12th grade.
All right. And what are you planning to do with the rest of your life?
So I want to actually, I've been watching news lately, and there's a lot of youth that are out there that's committing crimes, shootings, stuff like that. So I actually want to try to mentor youth.
Well, before you start mentoring youth, you got to.
Couple businesses, start a foundation.
I like to work with kids.
When's the last time you had employment, and what were you doing?
I have my own business, so I do mechanical work. So last employment was before I got arrested.
All right. So state any other conditions?
The judge is going to order him not to work with kids, literally, as a condition of his parole.
There's a low GPS. Okay, I understand. Defense, I'm assuming you don't want GPS?
No, yeah.
All right, so here's the thing. If I give him GPS, then I will set his bond at $2,000 because I know there's some issues with the GPS. So he can obtain GPS, have a $2,000 bond, and what I'll do is I'll do partial GPS for employment. I always believe in giving people things to think about. You want to discuss it with your client?
Is it worth $8,000?
All right, I'll have you all discuss it with your client.
The client does not want GPS.
And they will come back.
But the judge is giving them an $8,000
Who's
break
here?
on the
Renee
bonds if they'll take a
Camarillo, are you all
GPS.
ready?
The right answer is yes, take the GPS. Otherwise, it's like, oh, I don't want to be tracked.
And everyone, we're going to take our break at noon. All right. So you received all the discovery. State, were you able to tender an offer?
Yeah.
How old are you?
17.
All right, Ms. Ferguson, I'm going to recall this in 45 days for a plea deadline date. If you need less time than that, you can always come back, but you're very young, so I want you to have a chance to think about the impact a plea will have on your life.
Mm-hmm.
All right?
Most kids don't think far beyond tomorrow.
All right, we'll be back on October 7th. Again, if your attorney wants to bring you back over sooner than that, she can always have you brought over sooner. All right? Do you have any questions about anything?
No, ma'am.
All right, thank you.
All right, we're gonna bail on Judge Boyd here for a little bit. The inmate, the defendant, just a bit ago, he says, "I want to work with kids and be a mentor." I love that. I love that people want to be a mentor. I would say wait for a bit. To be a mentor, you need to have a pattern. You need to be able to basically have a life experience and pattern that is something you can build on and teach and demonstrate. When you're standing in cuffs in front of the judge for literally breaking the law and saying, "Hey, I'm going to teach kids," I would say the answer is no. Now is not the time. You might need a couple years, maybe. Get your life straightened out, get everything fixed, make restitution, if you're on bond, abide all the, then start looking at bettering yourself and seeing how you can reach out and lift people up. But it's very hard to lift people up when you are at a level that, ideally you're talking to kids, you're trying to prevent them from committing crimes. You are literally below them. You're in the slammer. How do you lift someone up from that position? It doesn't work very well, but I love that people want to do that, and I think that there needs to be more of it. I like it myself. I've worked with as a mentor and in scouting, as in youth groups, and the kids these days are so much smarter than we were when I was kids. I kid you not. They're so smart, and they have such big dreams and ambition, and a lot of times they just need a little help and guidance. And those of us that have a little bit of experience in that area might be able to give them something, and then they can go and shoot off and reach the stars. But if you get the opportunity and you're in a position where you can mentor kids, I highly, highly suggest you do it. It's extremely rewarding, and there's very few things that are as rewarding as seeing somebody achieve something just spectacular with their lives because they got a little bit of guidance and good instruction as a youth. Sample user says, "I'm a mentor in chat." Yes, Adam, you are a mentor. All right, here's what we have coming up. We are just a wee bit, let's see, we are about 40 minutes away from trial for Robert Tellis. So we're going to take just a little bit of a break. We have the new thumbnail up for the live stream for court. As soon as that's up, well, we're going to take a break and we're going to come back on that one. I'll talk a little bit about the case, what's happened so far. The defense obviously is up with our case in chief. The prosecution has rested. That's what happened yesterday. So we'll talk about the evidence that we've received so far. We might show the walk video back and forth as we're comparing the gait of the defendant and the assailant, which the state says is the same person. So we'll talk about that a little bit, about what we might expect from defense moving forward. Will the defendant testify? Will he take the stand? Does he have that personality where he just has to talk? Is this like the male version of Sarah Boone? I'm curious. I think it might happen. There's so much he wants to say. We see it in his face every single time we watch court. But there's a chance that's going to happen. Maybe his lawyers have convinced him otherwise, because I don't think it's a good idea to do that. But anyway, lots coming up. We don't know exactly how long the case will go with the defense. This case was slated for 2 weeks, which means it would sort of be wrapping up this week. So we could be in verdict watch here in the next couple days. But anyway, it's gonna be fun. It's probably gonna be spicy because defense is doing what they have to do here, which is misdirect and confuse. There's been a lot of very direct, compelling evidence. The defense needs people to look other ways. They need to look at something else. The example in chief is yesterday when the defense brought all those pictures that were taken at the police station of Mr. Tellis, down in his boxers. They showed every single picture except for the one that had the cut on his finger, which would be used as evidence that he was involved in a knife attack or possibly cut himself while snipping up his shoes until it's tiny pieces. They want people to look other places, and so we expect in the testimony today they're going to do the same thing moving forward. Look at all the other things that are happening. Look at the things that don't point to Robert Tellis. It's going to be interesting. So, verdict watch won't even be long enough to play the whole verdict song. We're gonna have the verdict song for sure. We'll fit it in, even if I have to pause the video. Yes, the state has finished their case in chief. We're gonna portal over to the new give me like a 10-minute break. Is that all right? I want to check in with the family. Family's going to do a tour of an Amazon distribution center today. Did you know that's a thing? You can like email them and say, hey, we'd like the tour. And they have a list of things. You have to wear closed-toed shoes. Everyone over 18 has to have ID. You can bring your cell phones, but no cameras, and all those sorts of things. You abide by those conditions. And they'll take you in the factory where we get to see all our products getting moved around by robots and then shipped out the door. So that's pretty cool. But just know we are going to portal over to the other side. It's going to be a few minutes before we go live. I think I had it slated for 15 minutes from now, but I'll probably be just a tiny bit early. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again in just a few minutes. I want to leave you here with this beautiful day outside. Absolutely beautiful. Check out those clouds. I mean, you can't paint these things. That is just... Oh, there's an airplane. You see the airplane? See if I can... Oh, I lost it. There it is. Trying to focus on the plane here. I think it's a little Cessna. Little 2 or 4 passenger. Anyway, have yourselves a wonderful day. We're going to be back in just a minute with on the other side with the Robert Tellis trial. Thank you all. We'll see you in a little bit. Bye-bye.